Hello, this is Larry Hall. Welcome back to part two of our course on legal status in the USA. And we want to start off today's course with a bit of a review of some of the things we learned in the first part of the course, where we laid the foundation for understanding legal status, citizenship issues, sovereignty, and who holds it. We learned how the African American of slave descent is one of the sovereign people, and we learned the distinctions between all these related issues. So let's take a few minutes to review some of what we learned in that part one. The first thing we learned, which most people are probably weren't even aware of before that, was that there are three constitutions that comprise our Constitution today. And we know from reading the parts of those and applying them that it is literally impossible to understand any one of those documents without understanding the ones that went before it. So it's one of the difficulties people have in reading the current Constitution is without reading and understanding the Declaration of Independence, Articles of Confederation, and other documents, Magna Carta and so forth. You can't totally understand the meaning of the document. So the three constitutions we had were the Declaration of Independence of 1776, the Articles of Confederation of 1778, and our current Constitution of 1787. We learned that those citizens who are not 14th Amendment United States citizens include the people, and included within the people are African Americans of slave descent. And those other citizens who are not 14th Amendment citizens are those whose ancestors held state citizenship prior to the 14th Amendment. And both of these classes of citizens are state citizens first and not citizens of the United States at all, as 14th Amendment citizens are. All other persons are 14th Amendment citizens subject to the jurisdiction of the United States and liable for the national debt via the income tax. We understand now from working through it in our first part that 14th Amendment citizens simply cannot rescind their citizenship, and the only way to change it is their legal status is through marriage or legal adoption. We learned that all natural beings are persons, but within the definition of the state or any of the state or the federal Constitution, all persons are not people. We've learned that these supposed other classes of citizenship or legal status that people talk about a lot, such as American, sovereign personam sojourn, a free man on the land, a private people of posterity, God's own sovereign, whatever, goes on, the list goes on and on, are simply made up names that do not exist in any legal context. We can't just make up our own classification of citizenship or legal status. We are, after all, a law of nations, and we have to abide by those laws. The people are only those and their posterity upon whom King George III devolved his sovereignty, and it resides only in the people. All other than people are known to be the persons, and their rights are described in the Fifth Amendment. From the Declaration of Independence, we learn that all men are endowed with certain unalienable rights, and that among these are life, liberty, and the pursuit of happiness. These are natural rights, and we refer to them as civil rights. The source of the sovereignty was the Treaty of Paris of 1783, as revealed early on by the U.S. Supreme Court in Chisholm versus Georgia. That case laid out the whole story, telling us that the people are equal as fellow citizens and as joint tenants in the sovereignty. Further to review what we've already learned, we're going to make a list of some of the attributes of the sovereignty, pull them together from all that information in part one, and list them here. So number one is we have where rights secured by the Constitution are involved, there can be no rule-making or legislation which would abrogate them. If the people reserve certain rights for themselves or for the persons in the Constitution, Congress has no authority to diminish those rights without the consent of the people, not the persons. Congress may not make and the President may not approve any rule or legislation which is an abrogation of the sovereignty. When one of the people serves in an official capacity, governmental capacity, such as President, Senator, Representative, etc., he does so as a person and not in his sovereign capacity. That doesn't mean that in his personal life he is still not the sovereign. It just means in his work, in his duties, official duties, working within a position in the government, he is a person in that context. We learn that sovereignty is not subject to the law, as sovereignty is the author and source of the law, and the law is the definition and limitation of power. The sovereign is not bound by a statute unless it is made by express words to extend to him. The following illustrates that point very, very clearly. It is true that in years past, back in the 1800s, there were two separate California statutes that addressed the offense of dueling. One statute stated that any person convicted of dueling would receive a prison sentence. The other statute stated that if any of the people were convicted of dueling, they would lose their right to vote. So persons could go to prison for dueling, people just lose their right to vote. This example recognizes the distinction between people and persons and shows how a law must name the people to bind the people. As another example, there were two other California statutes in the 1800s that illustrate the same concept. One required all persons to register names on a particular list of persons. The other required all people to register the names on a particular list of people. Obviously, the people of California wanted to know who the persons were in their state. Continue with our list of attributes of the sovereignty. Nothing is to be presumed where the rights of the people are concerned. Acquiescence in loss of fundamental rights will not be presumed, and nothing is to be taken away from the sovereign without the permission of the sovereign. The king never taxes himself or his own. In keeping with the concept of the nature of sovereignty, held by the people and the rules already laid down in the Articles of Confederation, the people are not subject to the income tax. Now let's make a list from what we've learned of the rights of the sovereign people. And again, this is not a complete list, but contains most of them. The number one right, and probably the most important right and most valuable right on the planet, is a joint tenant in the share of the United States of America and the state of the people's residency. The right to alter, amend, or abolish the constitutions and the governments they created. See, only the people can change the Constitution. So any amendment to the Constitution that is voted on by even one person, if there's even one person voting on that, that amendment has no effect whatsoever. It is not a real amendment to the Constitution. The right let's see, where are we here? Freedom of speech and of the press. The people, it's only the people that have the right to freedom of speech and the press. The right to peaceably assemble. The right to petition government for redress of grievances. The right to keep and bear arms. The right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. No warrant shall issue but upon plausible cause against the people, supported by oath or affirmation, and not on information and belief, and particularly describing the place to be searched and the persons or things to be seized. The enumeration by article, section, clause, or amendment in the Constitution of certain rights shall not be construed to deny or disparage others retained by the preamble people and their posterities. Amendment 9. You see, just because certain rights are specifically enumerated and therefore specifically reserved to the people in the Constitution does not mean that other rights not specifically enumerated and listed are not also reserved to the people. Anything not granted to the governments, on the other hand, in the Constitution, is absolutely reserved to the people. So something has to be specifically granted to government, but it doesn't have to be specifically reserved to people. people preserved all of the rights that they did not give away. Looking at Amendment 10, the power is not delegated to the United States of America by the Constitution, nor prohibited by it to the states, or reserved to the states respectively, or to the preamble people and their posterity. So government only receives such rights as were specifically delegated. All others are specifically reserved or denied. And winding up our list, any one of the people may join with a person already a plaintiff as a co-plaintiff in an action brought against the government in the manner of a mandamus to enforce the rights of the person. This effectively extends the power of the people to petition the government to the persons. We'll be learning more about that in Part 2. And the people can exercise those political rights, in other words, that legislative authority reserved to the people. Remember that our first constitutions were political documents. Our current one is a civil document, and all of the political rights were reserved to the people. And the people have access to the common law and Magna Carta. That's going to wind up our review, except for one thing. What I'm going to do here is read a couple pages out of the about 80-page case of Chisholm versus Georgia. We've already read a few excerpts. Because this case is so important, and it's so important to understand the context of it and how eloquently this was written and how carefully they explained where the sovereignty came from and who holds it and the balance of power in this country. I think it's of importance to this course to read just a little more, so bear with me while I read about 2 pages from that court case. First, we'll hear a short excerpt from one of the justices, Justice Blair, where he says, "Whatever be the true language of that, the Constitution, it is obligatory upon every member of the Union, for no state could have become a member but by an adoption of it by the people of the state." So he's letting us know that it was not the state, it was the actual people themselves in their sovereign capacity that formed this country. Now we hear from Justice Wilson, and he's referring to the Constitution here when he says, "With regard to one of the terms, the word state, this authority is declared in the Constitution. With regard to the other, the word sovereign, the authority is implied only in the Constitution. But it is equally strong, for in an instrument well drawn as in a poem well composed, silence is sometimes most expressive. To the Constitution of the United States of America, the term sovereign is totally unknown. There is but one place where it, the term sovereignty, could have been used with propriety. But even in that place, it would not, perhaps, have comported with the delicacy of those who ordained and established that Constitution. They might have announced themselves sovereign people of the United States of America, but serenely conscious of the past, they avoided the ostentatious declaration. The citizens of Georgia, when they acted upon the large scale of the Union as a part of the people of the United States of America, did not surrender the supreme or sovereign power to the state, but as to the purposes of the Union, retained it to themselves." Remember, in this case, Georgia was claiming that they were sovereign and not the people. The Supreme Court said otherwise. "As to the purposes of the Union, therefore, Georgia is not a sovereign state. The states rather than the people, for whose sake the states exist, are frequently the objects which attract and arrest our principal attention. This, I believe, has produced much of the confusion and perplexity which have appeared in several proceedings and several publications on state politics and on the politics, too, of the United States of America. Sentiments and expressions of this inaccurate kind prevail in our common, even in our convivial language. Is a toast asked, 'The United States of America,' instead of 'the people of the United States of America,' is the toast given. This is not politically correct. The toast is meant to present to view the first great object of the Union, the people. It presents only the second, the government. It presents only the artificial person instead of the natural persons who spoke it into existence. A state, I cheerfully admit, is the noblest work of man, but man himself, free and honest, is, I speak as to this world, the noblest work of God." Continuing, the people of the United States of America are the first personages introduced in the Constitution. Who were those people? They were the citizens of 13 states, each of which had a separate constitution and government, and all of which were connected together by Articles of Confederation. To the purposes of public strength and felicity, that confederacy was totally inadequate. A requisition on the several states terminated its legislative authority, executive or judicial authority it had none. In order, therefore, to form a more perfect union, to establish justice, to ensure domestic tranquility, to provide for common defense, and to secure the blessings of liberty, those people, among whom were the people of each of the states, ordained and established the present Constitution. By that Constitution, legislative power is vested, executive power is vested, judicial power is vested. If those states were the work of those people could alter as they pleased their former work to any given degree. They could diminish as well as enlarge it. Any or all of the former state powers they could extinguish or transfer. The inference which necessarily results, is that the Constitution ordained and established by those people could vest jurisdiction or judicial power over those states. The Articles of Confederation, it is well known, did not operate upon individual citizens, but operated only upon states. This defect was remedied by the National Constitution, which is all allowed as an operation on individual citizens. We may then infer that the people of the United States of America intended to bind the several states by the legislative power of the national government. One of its, the Constitution's, declared objects is to form a union more perfect than before that time had been formed. Before that time, the Union possessed legislative but unenforced legislative power over the states. Whoever considers in a combined and comprehensive view the general texture of the Constitution will be satisfied that the people of the United States of America intended to form themselves into a nation for national purposes. They instituted for such purposes a national government, complete in all its parts, with powers legislative, executive, and judiciary, and all those powers extending over the whole nation. Now we have a bit from Chief Justice John Jay from Chisholm versus Georgia. All the country now possessed by the United States was then, meaning prior to the Treaty of Peace, a part of the dominions appertaining to the Crown of Great Britain. Every acre of land in this country was then held immediately by grants from that crown. All the people of this country were then subjects of the King of Great Britain and owed allegiance to him, and all the civil authority then existing or exercised here flowed from the head of the British Empire. They were, in strict sense, fellow subjects and in a variety of respects one people. The Revolution, or rather the Declaration of Independence, found the people already united for general purposes, and at the same time providing for their more domestic concerns by state conventions and other temporary arrangements. From the Crown of Great Britain, the sovereignty of their country passed to the people of it. It is remarkable that in establishing it, the Constitution, the people exercised their own rights and their own proper sovereignty, and conscious of the plenitude of it, they declared with becoming dignity, and this is a quote, "We, the people of the United States of America, do ordain and establish this Constitution," end quotes. Here we see the people acting as sovereigns of the whole country, and in the language of sovereignty establishing a constitution by which it was their will that the state governments should be bound and to which the state constitutions should be made to conform. Every state constitution is a compact made by and between the citizens of a state to govern themselves in a certain manner, and the Constitution of the United States of America is likewise a compact made by the people of the United States of America to govern themselves as to general objects in a certain manner. By this great compact, however, many prerogatives were transferred to the national government, such as those of making war and peace, contracting alliances, coining money, etc. The sovereignty of the nation is in the people of the nation, and the residuary sovereignty of each state in the people of each state. J refers to that popular sovereignty in which every citizen partakes, and further states that officials are the officers of the people, remembering that in 1795 only the people were citizens. J refers to the citizens of the states as joint and equal sovereigns of the country. Okay, that concludes our summary of Part 1. I hope you enjoyed the reading from Chisholm versus Georgia. Amazing piece of literature and legal literature. I suggest everyone reads that court case in its entirety when you get the chance. Okay, we're going to move on now to section 12 of our course, which is concerning how the people protect the persons. And again, in this part 2 of the course, we're going to be talking mostly about remedies, remedies for the people, remedies for the persons, and how the two work together. So let's go right into this. The people are to enforce their powers in the state, to assure that all persons are treated equally, to assure that those to be governed actually have a consent, to assure that life, liberty, and happiness is preserved, and to assure that some group of persons does not get control via their right to vote so as to oppress all other persons. Unfortunately, because the people have been asleep, and I think they've been asleep partly because they don't know who they are, because they've been educated not to know who they are and not to understand their power and their authority and their duties as well. So that's why we have this course. We want to get the people awake again and get them back controlling and exercising their power in this country to get back on course. Using the rights that we have and what we have already learned, we can get real creative, and that's one of the things we're going to demonstrate in the rest of this course, and we can mix and match the resources available and create remedies such as the following. This involves the ultimate property right. The United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion and on application of the legislature or of the executive, but only when the legislature cannot convene against domestic violence. Article 4, Section 4 of the Constitution. So this is an important tool that we need to really think about and work on. We're guaranteed a republican form of government. We don't have it right now. Let's do something about that. That guarantee is in the Constitution, so no state government can take over and negate the political power of we the people in the state. Of course, there might be a warning notice at this time because they've already done it. Sworn public servants and legal licensees on and off the bench give lip service to we the people, but refuse to recognize our sovereignty and our sovereign immunity in the courts. We have to address that issue. In and of itself, the rule at Article 4, Section 4 of the Constitution that we just read grants a superior jurisdiction in the courts of the United States. The only other way to enforce the rule would be by military force of arms. In Chisholm versus Georgia, the court was trying to prevent use of military force by providing a forum to litigate such as an issue. That is why the U.S. Attorney General represented Mr. Chisholm. Remember this case here, Commonwealth ex rel. Hancock versus Paxton. It is true that at common law, the duty of the Attorney General was to represent the king, he the king being the embodiment of the state. But under the democratic form of government now prevailing, the people are the king, so the Attorney General's duties are to that sovereign rather than to the machinery of government. When we the people learn that all persons are not being treated equally, when we learn that sworn public servants and legal licensees, on or off the bench, state and federal, are oppressing the rest of the persons by claiming immunity for unlawful acts, then it is time for we the people to intervene. A member of the class known as people may be added as a real party in interest in a case to which a person is a party. So this is a routine we can work with. We know that the Attorney General has to represent the people, so why not add a people to a case where there's a person and bring in that power? Such member of the sovereign constituency would represent the people as a joint tenant in the sovereignty, in defense of the absolute sovereignty and sovereign immunity of we the people as declared in the Constitution of July 4th, 1776. This is confirmed by the ruling of the U.S. Supreme Court in Chisholm versus Georgia. The U.S. Attorney General must represent both the person and the joining member of the sovereign constituency. That duty may be enforced by the courts under Title 28 U.S.C. Section 1361, which states, the district courts shall have original jurisdiction of any action in the nature of mandamus to compel an officer or employee of the United States or any agency thereof to perform a duty owed to the plaintiff. Okay, so that's something for us to think about and figure out all the ways we can apply this so that the people can come to the aid of the persons as well as themselves in these out-of-control courts that we have. The next section is Section 13, which talks about sovereign immunity of the courts. They claim to have it, but do they really? I say not. When we the people assumed the sovereignty on July 4th, 1776, we accepted the sovereignty on the same terms and conditions upon which it was held by George III. We went to war with George III because he forgot that the sovereign had already waived its immunity on certain subjects under Magna Carta in 1215 A.D. Very important issue. He just forgot about that, so we took him to task. We exercised our right to declare war on the crown under Magna Carta Article 61. Cromwell had revolted and took the head of Charles Stuart for the exact same causes, but Cromwell restored the crown to another king. This time we didn't restore the crown to a king, but kept it for our 1787 selves and our 2009 posterity. We the people are still bound to the same rules as was the King of England as follows. We're going to look at sections out of articles out of Magna Carta where the king is still bound. In like manner, let it be concerning the aids of the City of London. The City of London should have all its ancient liberties and its free customs, as well by land as by water. Furthermore, we, the sovereign, will and grant that all other cities and burghs and towns and ports should have all their liberties and free customs. It's Article 13. Article 20, a free man should not be fined for a small offense, but only according to the degree of the offense, and for a great delinquency, according to the magnitude of the delinquency, saving his contentment. A merchant shall be fined in the same manner, saving his merchandise, and a villain shall be fined after the same manner, saving to him his wainage. And if he shall fall into our mercy or judgment, and none of the aforesaid fines shall be assessed, but or except by the oath of honest men of the vicinage. Got some of those honest men we're looking for. Let's look at Article 28 of Magna Carta. Still incumbent on the king. No constable nor other bailiff of ours shall take the corn or other goods, including automobiles, they do like to take automobiles, of anyone without instantly paying money for them, unless he can obtain respite from the free will of the seller, not the legislature. In other words, they can't say, hey, you didn't pay a traffic ticket, we're going to take your car. It's not allowed, no way, no how. Let's look at Article 30. No sheriff or bailiff of ours, nor any other person shall take the horses or carts or automobiles of any free man for the purpose of carriage without the consent of the said free man. Article 36. Nothing shall be given or taken for the future for the writ of inquisition of life or limb, but it shall be given without charge and not denied. Article 3. No bailiff or public officer for or in the future shall henceforth put any man to his law upon his own simple affirmation, as on a traffic citation, without credible witnesses produced for the purpose. So, police officer pulls you over, he's got to have a witness or he can't proceed with a traffic citation against the people. Question, does the above rule allow for summary dismissal on an action on the basis of stare decisis, such as a claim of sovereign immunity of the court? Think about that for a while. Let's go to Article 41. All merchants shall have safety and security in coming into England and going out of England, and in staying and in traveling through England, as well as by lands as by water, to buy and sell without any unjust exactions, according to ancient and right customs, excepting the time of war. Article 42, it shall be lawful to any person for the future to go out of our kingdom and to return safely and securely by land or by water, saving his allegiance to us, unless it be in time of war for some short space for the common good of the kingdom. Article 45, we will not make judiciaries or judges, constables or police officers, sheriffs or bailiffs, including lawyers, excepting such men or women as know the laws of the land as stated in Constitution Article 6, Section 2, and are well disposed to observe them rightly. Boy, is this an important article. Just imagine how far we are off of this beaten path. None of this is happening whatsoever today. Let's take a look at Article 52. If any free man have been disposed or disposed by us without a legal verdict of their peers, of their lands, castles, liberties, or rights, we, the sovereign, will immediately restore these things to them. And if any dispute shall arise on his head, then it shall not be determined by the courts, but shall be determined by the verdict of the 25 barons of the people's grand jury, of whom mention is made below Article 61 for the security of the peace. You see in Magna Carta, Article 61, the sovereign agreed that if he should ever violate any of the above articles from Magna Carta, and should a petition for redress of grievances be denied or not be forthcoming, the sovereign waived his own immunity, saving his life and the life of his queen and children, and in doing so he granted the barons the legal capacity to make war on the king, the sovereign. So that is exactly what we the people did on July 4th, 1776. Subsequently in 1791, Constitution Amendments 1 and 2, we the people assumed the duties of the barons under Article 61 in our joint tenant sovereign capacity. As sureties of the public peace, only we the people can petition government for redress of grievance. Only we the people have the right to bear arms in the state so as to enforce our judgments under Article 61. So yes. So we see that the people in the United States, the sovereign people, are the only ones that can petition government for redress of grievance under Amendment 1, and also that they're the only ones under Amendment 2 who can bear arms. So they have stepped into the place of the barons in exercising the rights that we just read at Article 52 of Magna Carta. So that's how all that has devolved on the people in the United States. They were at once the sovereign and at once also the barons. So if the sovereign waived its own immunity under Magna Carta Article 61, remember the sovereign says if we don't do these things right, then you can take us to task. And that's where they waived the king waived his sovereign immunity, and that's where the people in the United States have waived their immunity. Then where does the sworn public servant or legal licensee, owner off the bench, propose to get any immunity superior to his sovereign master, the people, to whom the oath is sworn, the oath that they take when they go into office as a public servant? The only immunity a sworn public servant or legal licensee can claim is saving their life and the life of their wife and children, because that is all that remains to the sovereign under Article 61 if Magna Carta is violated. They cannot now claim immunity of their property, as the king waived his goods and even waived his lands and castles. In exchange for allegiance, the sovereign's duty is to protect the subjects and their rights and liberties. So when Georgia's claim of immunity failed in Chisholm versus Georgia, state politicians and the legislatures all over the country were made aware that if such power existed under the United States, then they were all very much in jeopardy. The politicians jumped right on the bandwagon and proposed and ratified the 11th Amendment. Now, the 11th Amendment doesn't say anything whatsoever about the subject of sovereignty or sovereign immunity, but simply alters the language of Article 3. So here is Article 3, Section 2, Clause 1 of the Constitution. The judicial power, this is the way the Constitution was originally written. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States of America, and treaties made or which shall be made under their authority, to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, which is Chisholm versus Georgia situation, between citizens of different states, between citizens of the same state, claiming lands under grants of different states, and between the state or the citizens thereof and foreign states, subjects or citizens or subjects. Now, that's the way we started out. State legislatures figured out that they were at risk because all of a sudden they weren't sovereign, and so they proposed the following, which is Amendment 11 to the Constitution. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States of America by citizens of another state or by citizens or subjects of any foreign state. So they effectively removed one of the clauses from Article 3, Section 2, Clause 1, and reduced the number of circumstances under which the state could be sued. So, the 11th Amendment, what did it do? It removed the original jurisdiction of the U.S. Supreme Court to hear such controversies as originally contained in Article 3, Section 2, Clause 1. Originally, under the actions that are described in Article 3, Section 2, Clause 1, you filed your original suit in the Supreme Court. You did not start with the lower court and move your way up. The Supreme Court had original jurisdiction in the matter. Amendment 11 removed the ability of any federal court to hear such controversies. Okay? And it removed the ability of Congress to alter the rule in the future by statute. They'd have to amend the Constitution again to alter the situation. So we come to 1866 now, and remember the 11th Amendment was back before the turn of before 1800. It was late 1700s. In 1866, Congress passed the 14th Amendment, which effectively invalidated what they'd accomplished in the 11th Amendment. And this is, let's read here, where it says, all Article 1, Section 9, Clause 1, migrating or imported persons born or hereafter naturalized in the United States of America and still subject to the jurisdiction thereof, including the Indians, are declared to be federal citizens of the United States first, and of the state wherein they reside second, pursuant to the Civil Rights Act of 1866. Thus, no Union state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States of America as declared in Amendment 5, nor shall any state deprive any Article 1, Section 9, Clause 1, migrating or visiting person of life, liberty, or property without due process of law, nor deny any person within its, the United States of America, jurisdiction of the equal protection of the laws is guaranteed to persons in Amendment 5 to the Constitution. That's Section 1 of the 14th Amendment. Declared ratified in 1798, the 11th Amendment removed the convenient forum of the U.S. Supreme Court for which redress could be sought from the state. The 14th Amendment of 1868 established an even more convenient forum because now a plaintiff can present a case against the state before the nearest district court of the United States to enforce the duty under Title 28 U.S.C. Section 1361, which reads as follows. The district court shall have original jurisdiction of any action in the nature of mandamus to compel an officer or employee of the United States or any agency thereof to perform a duty owed to the plaintiff. So this is how the game works. At any time, two separate and distinct sovereignties are at work. In their own state, the people of any single state are 100% sovereign. The majority dictates the policy of the single state. The sovereignty of the United States of America consists of the collective sovereignty of all 50 states. No single state or any minority states can dictate the policy of the United States. Let's read the court case. I guess I didn't plot that up for you. Sorry about that. The general federal government and the states, although both exist within the same territorial limits, are separate and distinct sovereignties, acting separately and independently of each other within their respective spheres. The former in its appropriate sphere is supreme, but the states, within the limits of their power not granted, or in the language of the 10th Amendment reserved, are as independent of the general government as that government within its sphere of independent of the states. Dobbins versus Erie. In making a federal citizen in Section 1 of the 14th Amendment, and in naturalizing persons who arrived after July 28, 1868 as federal citizens instead of state citizens, the United States federal citizens are, under the broad sovereignty of the United States of America and under the narrow sovereignty of a single state. So we, the people, gave the United States Congress the power to dictate the policy and to enforce that policy in the single state. To that extent, and for those important purposes, in ratifying the 14th Amendment, the state sovereign waived its immunity for all persons employed by the state. This includes the judges. Federal courts have jurisdiction whether they like it or not. And here's the rule from Chief Justice Marshall, where he says, the United States is a government and consequently a body politic and corporate capable of attaining the objects for which it was created by the means which are necessary for their attainment. This great corporation was ordained and established by the American people, not the persons, and endowed by them with great powers for important purposes. Its powers are unquestionably limited, but while within those limits, it is a perfect government as any other, having all the faculties and properties belonging to a government, with a perfect right to use them freely in order to establish the object of its institution. U.S. versus Morris. Since all states are subject to the 14th Amendment, the national sovereignty waived its sovereign immunity as to persons in its employ operating in the several states, including all persons who are federal officers and judges working in the state. In other words, no person is immune by reason of official capacity, including the incorporeal persons of any state or official or employee thereof. Question: how can we the people give persons sovereign immunity for unlawful acts when we the people in our sovereign capacity have no such immunity to give? The sovereign waived its sovereign immunity as to persons in its employ some 782 years ago. Thus, if we the people are legally incapacitated in Magna Carta for doing such unlawful acts, then just where do the persons maintain that they get their legal capacity? Okay, that concludes our section on immunity. Now, if you can see, if you follow that through, read that over and over, and understand why the courts do not have the sovereign immunity that they claim. And they need to be taken to task on that, because they use that as a crutch, and they have put court cases on the record that where they claim to have sovereign immunity and use that to throw out proceedings against the court, proceedings against the officers of the court, the judges, and it is an absolute lie, and it's a large lie at that. It's a biggie-sized lie, and it ain't so, and it never has been, and it never will be. Okay, we're going to move on to section 14. And Section 14 has two parts. Part A that we're about to go into is the undeclared fourth branch of government, the 25 Baron or People Grand Jury. Part B is the Fifth Amendment Grand Jury. So what we've learned already that we the people are still bound to the same rules as was the King of England at Magna Carta, Articles 3, 13, 20, 28, 30, 36, 41, 42, 45, and 52. And in Magna Carta, Article 61 provides that what may be called the undeclared fourth branch of the government of the people, for the people and by the people. As sureties for the public peace, we the people have both the legal capacity and the power to overturn any judgment or law in these United States of America. Our judgment is final as there is no higher court in the realm. In other words, any decision by any court, any law passed by any legislature can be overturned by we the people, acting as a 25 people Magna Carta Article 61 grand jury. Okay? All sworn public servants are already under oath to support and defend that judgment. So they've already sworn to support what we do. It's not my problem that they don't know the law. However, they've already taken an oath to support it, and this is the law. Nothing's changed. Magna Carta is still in place as to the sovereign, just as it always has been. And when it's in place to the sovereign, it is incumbent upon the public officers that represent the sovereign. Pursuant to the Treason Act of 1703, which is judicially noticeable in every state, all public officers and employees, including legal licensees on and off the bench, can be hung for treason and have their estate seized and forfeited should they violate that oath. The stage is being set to discover who we, the people, are protecting and why. We, the sovereign, guarantee to our subjects the following. And we're going to go back to Magna Carta and read some articles from there. Article 39. No freeman, meaning a 14th Amendment citizen, shall be seized or imprisoned or disposed or outlawed or in any way destroyed, nor will we, the sovereign, condemn him, nor will we commit him to prison, excepting by the legal judgment of his peers or by the laws of the land. Article 40. To none will we, the sovereign, sell. To none will we deny. To none will we delay right or justice. Article 52. If any 14th Amendment citizen have been disseized or dispossessed by us, the sovereign or the sworn servants of the sovereign, without a legal verdict of their peers, of their lands, castles, liberties, or rights, in violation of Magna Carta Articles 39 and 40, we, the sovereign, will immediately restore these things to them. And if any dispute shall arise on his head, then it shall not be determined by the courts, but it shall be determined by the verdict of the 25 people, of whom mention is made below in Article 61 for the security of the peace. Moving on to Article 55. All fines that have been made by us unjustly are contrary to the laws of the land, and all fines that have been imposed unjustly are contrary to the laws of the land, shall be wholly remitted or ordered by the verdict of the 25 barons of the people's grand jury, of whom mention is made below in Article 61, for the security of the peace, or by the verdict of the greater part of them. And so in Magna Carta, Article 61, the sovereign agreed that if he should ever violate any of the above, and should a petition for redress of grievances be denied or not be forthcoming, he agreed as follows. The sovereignty was waived, saving his life, the life of his king and children. In doing so, the barons were granted the legal capacity to make war on the sovereign. That's exactly what we the people did on July 4th, 76. Subsequently, in 1791, in Constitution Amendments 1 and 2, we the people assumed the duties of the barons under Article 61 in our joint tenant sovereign capacity. Now, as sureties of the public peace, only we the people can petition government for redress of grievance. Only we the people have the right to bear arms in the state, so as to enforce our judgments under Article 61. So in exchange for allegiance from the subject, it is the duty of the sovereign to protect the subjects in their rights and liberties. Take notice that this author will change the English word baron to people in the following quotes, so you will understand the full force and effect of Constitution Amendments 1 and 2. But since this is going to be from Magna Carta 61, we're going to read it with substitution of words here so we can put it in context for today's meaning. But since we the sovereign have granted all these things aforesaid, for God and for the amendment of our kingdom, and for the better extinguishing the discord which has arisen between us and our barons, now the people under Constitution Amendments 1 and 2, we the sovereign, being desirous that these things should possess entire and unshaken stability forever. In other words, this rule rides in perpetuity. Give and grant to them the security underwritten in 1215 A.D., namely, that the people may elect 25 people of the kingdom, whom they please, who shall with their whole power observe, keep, and cause to observe the peace and liberties which we the sovereign have granted to them and have confirmed by this our present charter. In such wise, namely, if we the sovereign, or our sworn judiciary, if you please, or our bailiffs, or any of our officers, including sworn attorneys, shall have injured any one in the realm in any things, or shall have violated any article of the peace or security stated in Magna Carta, and the injury shall have been shown to 4 of the aforesaid 25 people, the said 4 people shall come to us, the sovereigns, or to our judiciary, if we be out of the kingdom, and making known to us the excess committed, petition that we the sovereign cause that excess to be redressed without delay. So the right of the people to petition government derives from the Magna Carta and is expressed in Constitution Amendment 1. Magna Carta Article 61 is not a catch-all for all occasions, though. This is a limited jurisdiction restricted to controversies which exist between the subjects of the sovereign, whose rights and liberties have been usurped, as against his sovereign or the sworn servants of the sovereign, and are a controversy which may arise between we the people and our sworn public servants, our legal licensees, on or off the bench. Persons have no legal capacity whatsoever to form a Magna Carta Article 61 grand jury, as they once did under the common law rule. The right is reserved exclusively to the class known as we the people, who hold the sovereignty as joint tenants. So a person, not even one person, may sit on a Magna Carta Article 61 grand jury. If they do, it invalidates anything that grand jury does. If you have a controversy with your neighbor, you take that controversy to a court of judicature, and a jury of your peers will judge the matter between you, meaning the parties, as Magna Carta Article 61 provides no such remedy. Magna Carta Article 61 is limited to a situation where you are deprived of your rights or liberties without a jury of your peers by either the sovereign or his sworn. It is not a court of general jurisdiction. It's a court of limited and special jurisdiction. While within that jurisdiction, it is supreme above all other courts. No appeal from a judgment of this court is allowed. So when the Magna Carta grand jury makes a decision, no court in the land can hear an appeal of that issue. They have no authority, no jurisdiction whatsoever. If you care not to be bound by its judgment, then stay out of this court at all cost, because contempt of this court is a capital crime under the rule in Deuteronomy 7:18-13. The Saxon sovereign cannot go from the right hand or the left of this rule, as mandated under the rule of Deuteronomy 17:14-20, because the terms and conditions of the treaty of 1 Samuel Chapter 8, otherwise known as the right of kings. The right to judge devolved from the Saxon king to we the people under the Treaty of Peace of 1783 and is provided in the Constitution of July 4, 1776, as declared in the 1787 Constitution Amendments 1 and 2, and is reserved exclusively to we the people under Amendments 9 and 10. Reading from Deuteronomy 17:8-13. If there arise a matter too hard for thee in judgment, between blood and blood, between plea and plea, and between stroke and stroke, being matters of controversy within thy gates, then thou shalt arise and get thee up into the place which the Lord thy God shall choose. Paraphrasing that from that book, the judge shall show you the sentence of judgment. He shall do according to the judgment and not go to the right hand or to the left of the judgment. He who does not follow the judgment shall die. Further in Deuteronomy 17:14-20, I will set a king over you, like as all the nations that are about me, but he shall not multiply horses to himself, neither shall he multiply wives to himself, neither shall he greatly multiply to himself silver and gold. He shall write him a copy of this law in a book. He shall read therein all the days of his life, talking about the king here, that his heart be not lifted up above his brethren, and that he turn not aside from the commandment to the right hand or to the left. If in fact you have a controversy with one of your sovereign sworn public servants, or a legal licensee's owner off the bench, then we the people who are sovereign will judge your case. If first your case is deemed to be righteous by 4 of the 25. And this is where the Treason Act that we talked about, Treason Act of 1703, comes in. It's alive and well. It is a capital crime for any person who is a sworn servant of the sovereign to interfere with the successors to the English crown. Such capital crime is within the exclusive jurisdiction of the grand jury at Constitution Amendment 5. Let's look again at Article 61, Magna Carta, as it continues. And if we, the sovereign, shall not have redressed the excess, or if we have been out of the kingdom, if our judiciary shall not have redressed it within the terms of 40 days, computing from the time when it shall in mode known to us, or to our judiciary, if we have been out of the kingdom, the aforesaid 4 people shall lay that cause before the residue of the 25 people, and they, the 25 people, with the community of the whole land, including everyone under oath in the state. That means all the sworn public servants are subject to this as well, shall distress and harass us, or the government of the sovereign, by all the ways in which they are able. Continuing, that is to say, by the taking of our castles, lands, and possessions, and by any other means in their power, until the excess shall have been redressed according to their verdict, saving harmless our person and the persons of our queen and children, and when it hath been redressed, they shall behave to us as they have done before. So, you get the redress, and then everybody goes back, and it's happy times again. In the Constitution, Amendments 1 and 2, we the people, in our joint tenant sovereign capacity, assume the office and duties of the barons and Magna Carta as sureties of the public peace in our respective counties. Persons no longer have the legal capacity to petition government for redress, which is why criminal cases are filed in the name of the people of the state. Persons do not have the right to bear arms in the state so as to make war with the sovereign under Magna Carta 61, as did we the people on July 4th, 1776. Only we the people can do a lawful revolution in this country, and it is legally impossible for we the people to revolt against ourselves. Revolution is now a moot issue in America. If the persons try it, it's treason. Back to Article 61. And whoever of our land pleaseth may swear that he will obey the commands of the aforesaid 25 people, noting that every one of our public servants are already sworn under the Constitution, Article 6, Section 3, in accompanying all the things aforesaid, and that with them he has agreed that he will harass us, or our government, to the utmost of his power, and we publicly and freely give leave to everyone to swear who is willing to swear, noting that each of you public servants did voluntarily swear with no mental reservation whatsoever, and we will never forbid any to swear. But all of those of our lands who of themselves and of their own accord are unwilling to swear to the 25 people, to distress and harass us together with them, we will compel them by our command to swear as aforesaid. So if the king's out of kilter here and he's been doing something wrong, 25 people bring the matter in a petition to the king doesn't do anything or doesn't repair the damage done, then anyone and everyone, including the legal licensees and government employees and so forth, are required to take an oath to go and take the property of the government to satisfy the judgment. So quite an interesting situation for the judge or someone to be in. And if any one of the 25 people shall die or move out of the land, or in any other way shall be prevented from executing the things above said, they who remain of the 25 people shall elect another in his place according to their own pleasure, who shall be sworn in the same manner as the rest. Okay, so the people have devised a system by which they can admit foreigners to citizenship, allow them to vote and hold office, and still have legal recourse or remedy. The people have devised a system by which they can allow persons to become sworn public servants and legal licensees on or off the bench and still be able to intervene on behalf of the persons. Under the common law, the subject always had a right of appeal to his sovereign. In this country, the 25-man people grand jury, about Article 61 of Magna Carta, is one method by which it is done. In the Constitution, the people reserved an absolute right to petition the government for a redress of grievances, and at the same time restricted Congress from prohibiting their exercise of the right. Amendment 1 to the Constitution, Congress shall make no law prohibiting the right of the people to petition the government for a redress of grievances. No law. Absolutely none, ever, no way, no how. Rights reserved exclusively to the sovereign are generally enforced via extraordinary relief such as prohibition, mandamus, and writs of habeas corpus, and or writs of error or certiorari on the subjects of the writs, as opposed to a trial of the facts in inferior courts. So we don't have to go to an inferior court and ask permission, oh, would you please? We can issue a writ. An example of granting this type of extraordinary relief is shown in the following ruling. Jolicoeur and Millahay, something like that. There is no stronger statement of governing policy considerations in any particular circumstance than an express declaration embodied in our federal Constitution. Whereas here, in the instant case, such a declaration is manifestly dispositive of, or would self-dispose of, the single issue, then it holds that no good purpose is served by to make a concurrent examination of state or federal policies or legislative histories in an attempt to ascertain the facts that the supreme law of the land must be adhered to, because the fact is lesser policy considerations likewise require the exact same result. Continue with that case. Thus, the petitioners are entitled to their peremptory writ because the Constitution directs it, and we need not and should not seek otherwise in case law or statute simply to justify such clear constitutional direction. Boy, what is it that the courts don't get about this? It's already been stated, the Constitution states it, the courts have restated it. I don't understand what the problem is. The California court said the exact same thing the United States Supreme Court said in Miranda. It states that what the Constitution clearly says as to both the people and the persons. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. The First Amendment is probably the most important one. So the Constitution directs it, the people put it there. You can't go around it, under it, over it, through it by making legislation or policies or anything else, or by bringing court precedent into play. The people have an absolute and unqualified right to petition the government for grievances. That is true whether the petition is made by the four barons or any one of the people individually. The very First Amendment is the most important. Under the statutes of William and Mary, Magna Carta was made to be a part of the common law of England. Several states adopted the common law of England as a rule of decision in all courts of the states. If you want to know what the rights of persons are in the states, read Sir William Blackstone's Commentaries on the Common Law of England, Book 1, Chapter 1. In other words, the rights of persons are not in the Constitution, but rather are in the state constitutions and in the common law of England. Okay, that takes care of the Magna Carta grand jury, Article 61, 25 people grand jury. Let's look at the other grand jury that we have here in our section 14 in Part B. It's the other grand jury, the People's Common Law grand jury. It comes from the Fifth Amendment. In addition to the Article 61 Magna Carta grand jury, another grand jury is available to the people, the Fifth Amendment People's Common Law grand jury. That's a really long handle, so we'll just refer to it as the American grand jury as we go through our presentation here. This grand jury had its roots in England in 1166 under King Henry II. The Assize of Clarendon, which comes out of the Assize of Clarendon, which established a system of local informers, which at the beginning were 12 men from every 100 or 4 men from every village. Their job was to tell the king who was suspected of murder, robbery, larceny, or harboring criminals. The makeup or constitution of the grand jury changed under Edward III in the 13th century. 12 men were superseded by 24 knights chosen by the county sheriff. They had the authority for beginning a prosecution. The knights were called Les Grands Inquest, and this developed as part of the common law, not as a statutory matter. Now, the American grand jury began as a defense against the monarchy, not as an arm of the executive. And during the colonial period, it established a screen between accusations and convictions and initiated prosecutions of corrupt agents of the government. It had sufficient independence at that time to announce dissatisfaction with government, and as the revolution approached, it expressed outright opposition to the monarchy. The grand jury, unfortunately, was not provided for in the original Constitution or in the Judiciary Act of 1789. But with the adoption of the Bill of Rights, the Fifth Amendment established a grand jury. No person shall be held to answer for a capital, otherwise infamous crime, unless on a presentment or indictment of a grand jury. The grand jury was used to protect the people against arbitrary and overzealous government, and required a presentment or indictment. Let's just look at those words, make sure we understand them. A presentment differs from an indictment in that the presentment, is an accusation made by a grand jury of their own motion, either upon their own observation and knowledge or upon evidence before them, while an indictment is preferred at the suit of the government and is usually framed in the first instance by the prosecuting officer of the government and by him laid before the grand jury to be found or ignored. People versus Foster. This is from a Crichton Law Review called If It's Not a Runaway, It's Not a Real Grand Jury by Roger Roots, which states, in addition to its traditional role of screening criminal cases for prosecution, common law grand juries had the power to exclude prosecutors from their presence at any time and to investigate public officials without governmental influence. These fundamental powers allowed grand juries to serve a vital function of oversight upon the government. The function of a grand jury to ferret out government corruption was the primary purpose of the grand jury system in ages past. Well, that's the way it used to work. But by 1946, prosecuting attorneys had become commonplace at grand jury proceedings. Even though the wording of Amendment 5 has never been changed, the government managed to pretend to usurp the powers of the American grand juries as follows. Hearing from Mr. Roots more. In 1946, the federal rules on criminal procedure were adopted, codifying what had previously been a vast, divergent set of common law procedural rules and regional customs. In general, an effort was made to conform the rules to contemporary state of federal criminal practice. In the area of federal grand jury practice, however, a remarkable exception was allowed. Not sure about the word allowed, but it came in anyway. The drafters of Rules 6 and 7, which loosely governed federal grand juries, denied future generations of what had been the well-recognized powers of common law grand juries, powers of unrestrained investigation and of independent declaration of findings. The committee that drafted the federal rules of civil procedure provided no outlet for any document other than a prosecutor-signed indictment. In so doing, the drafters, at least tacitly, if not affirmatively, opted to ignore explicit constitutional language. In other words, they just failed to mention the fact that the grand jury could do an indictment on a presentment as well as an indictment. Here's Rule 7 of the Federal Rules of Criminal Procedure. An offense which may be punished by death shall be prosecuted by indictment. No mention of presentment. An offense which may be punished by imprisonment for a term exceeding 1 year or at hard labor shall be prosecuted by indictment. Again, no mention of presentment. So no mention of presentments can be found in Rule 7, but they are mentioned in Note 4 of the Advisory Committee's notes of the rules. Presentment is not included as an additional type of formal accusation, since presentments as a method of instituting prosecutions are obsolete. This is their commentary, at least as concerns the federal courts. And this is a comment by Professor Lester Orfield, a member of the Advisory Committee on the Rules of Criminal Procedure. He says, there was an annotation by the reporter, we just read that, on the term presentment as used in the Fifth Amendment. It was his conclusion that the term should not be used in the new rules of criminal procedure. Retention might encourage the use of the runaway grand jury, as the grand jury could act from their own knowledge or observation and not only from charges made by the United States Attorney. It has become the practice for the United States Attorney to attend grand jury hearings, hence the use of presentments have been abandoned. What a wonderful way to completely cut the people out of controlling their country and controlling their government. Just let the Attorney General do what he wants. If you wanted to bring an indictment against a government official that was involved in corruption, they've got their little system there to prevent that. The American Juror publication included a very relevant commentary on this move to usurp the power of the American grand jury. They said as follows. Of course, no statute or rule can alter the provisions of the Constitution, since it is the supreme law of the land. Well, no duh. But that didn't prevent the federal courts from publishing a body of case law affirming the fallacy that presentments were abolished, a particularly egregious example. And they use this example from a court case. A rule that would permit anyone to communicate with a grand jury without the supervision or screening of the prosecutor or the court would compromise, if not utterly subvert, both the historic functions of the grand jury, for it would facilitate the pursuit of vendettas and the gratification of private malice. A rule that would open the grand jury to the public without judicial or prosecutorial intervention is an invitation to anyone interested in trying to persuade a majority of the grand jury, by hook or by crook, to conduct investigations that a prosecutor has determined to be inappropriate or unavailing. Well, they continue as follows. What is the result? Investigating seditious acts of government officials can be deemed inappropriate or unavailing by the prosecutor or the judge, can dismiss the grand jurors pursuing such investigation. Consequently, corrupt government officers have few natural enemies and go about their seditious business unimpeded. Are you disgusted yet? They made a rule to take care of runaway juries too in 1946. At any time, for cause shown, the court may excuse a juror, either temporarily or permanently. In the latter event, the court may impanel another person in place of the juror excused. Rule 46(6)G. Now judges can throw anyone off a grand jury or even disempanel a grand jury entirely merely for exercising its discretion and going after corrupt government officials. We went to a whole lot of trouble to make sure the American grand jury could not be used to rein in the seditious activities of the sworn public officials, but they were only successful to the extent that the people allow them to get away with the big lie. The Supreme Court has stated otherwise. Justice Powell in United States v. Calandra stated, "The institution of the grand jury is deeply rooted in Anglo-American history. In England, the grand jury served for centuries both as a body of accusers sworn to discover and present for trial persons suspected of criminal wrongdoing, and as a protector of citizens against arbitrary and oppressive governmental action. In this country, the founders thought the grand jury so essential to basic liberties that they provided in the Fifth Amendment that federal prosecution for serious crimes can only be instituted by a presentment or indictment of a grand jury." Justice Powell continues, "The grand jury's historic functions survive to this day. Its responsibilities continue to include both the determination whether there is probable cause to believe a crime has been committed and the protection of citizens against unfounded criminal prosecutions." The United States Supreme Court, in United States v. Williams, Justice Scalia delivered the opinion of the court and laid down the law of the land, irrespective of what they did with the rules and people's opinions and footnotes to the rules. Rooted in long centuries of Anglo-American history, the grand jury is mentioned in the Bill of Rights, but not in the body of the Constitution. It has not been textually assigned, therefore, to any of the branches described in the first three articles. It is a constitutional fixture in its own right. The grand jury is an institution separate from the courts, over whose functioning the courts do not preside. Notice it's not part of the executive or the legislative or the judicial. Continues, "In fact, the whole theory of its function is that it belongs to no branch of the institutional government, serving as a kind of buffer or referee between the government and the people. Although the grand jury normally operates, of course, in the courthouse and under judicial auspices, its institutional relationship with the judicial branch has traditionally been, so to speak, at arm's length. Judges' direct involvement in the functioning of the grand jury has generally been confined to the constitutive one of calling the grand jurors together and administering their oaths of office. The American grand jury is properly conducted pursuant to the Fifth Amendment under the common law may only be constituted by the people. Persons may not be members of the American grand jury. There are several reasons for this. Reason number one, prior to the U.S. Constitution, grand juries were only comprised of the people, as only they were citizens and therefore only they held political rights. Upon the adoption of the USA Constitution, only the people were considered to be a part of the United States of America, the federal forum. The people who were granted citizenship, the persons who were granted citizenships were state citizens only and not a part of the national franchise. Thus, the persons, not being a part of the national franchise, had no access to serving on a grand jury, just like they had no access to sue in the federal courts prior to the Civil Rights Act of 1866. Nothing has changed to this day to permit the persons to serve on a grand jury. The Civil Rights Act of 1866, Section 1, gave the persons the right to sue in the federal courts. Section 1 of the 14th Amendment gave the persons access to the privileges and immunities, the civil rights, of citizens of the United States and equal protection of the laws. And Section 1 of the 15th Amendment gave the persons the right to vote, a political right. Nowhere were the persons given the political right of sitting on the American grand jury. The Constitution has not been changed on this point since its adoption, and no court case can do that, and no legislation can do that. Reason number 2, nowhere did the sovereign people give the persons the authority to set an indictment or judgment of the sovereign people. The king never does that, by the way. Even in Magna Carta, where the king gave the 25 barons the right to petition the government for redress of grievances, the king cannot be held strictly personally liable for his errors. And interestingly, every grand jury indictment brought since 1866 is most likely void on its face ab initio, simply on the basis that the grand jury was not properly constituted, since one or more persons were likely setting their own. And of course, if an indictment is void, any court verdict against the defendant in the ensuing court trial is void as well. Further, any indictment and any ensuing court verdict that has been brought since 1866, where the defendant was one of the people, and one or more of the jury members was a person, is void, simply because the persons may not set an indictment of the people. It is now our job to reclaim the American grand jury for the protection of the people and the persons against the seditious acts of the government. What we must do is make certain that those grand juries are properly constituted so that their decisions are not void, for the same reason that all other grand jury indictments have been void for the past 143 years. So I know that this is a big issue right now going on out around the country. Grand juries are being formed and indictments are being made. We need to make sure that these grand juries are properly constituted, because if there's one person sitting on any one of those grand juries, whatever they do has no force and effect whatsoever. Okay, that wraps up our discussion about the 2 grand juries. And now we'll move to Section 15 and determine and discover how the people immunize themselves from the unlawful acts of their public servants. You know, we the people didn't take direct control of the government ourselves, as did the King of England, where he made himself the responsible party. In fact, we the people formed the incorporeal government persons of the governments, state and federal, and then delegated the day-to-day duties of the sovereign to certain legally recognized persons defined in the constitutions and the statutes. So that puts all the natural persons who fill the offices directly under the control of the incorporeal person and not directly under the control of the person of the king. This leaves the incorporeal person totally responsible for the actions of the sworn public officials under the doctrine of ultra vires. The incorporeal person of a city, county, or state government is a legally recognized person within the meaning of the language of the various acts of Congress enacted to enforce the provisions of the 14th Amendment. The pains and penalties prescribed in those acts are not limited to just natural persons. They also include incorporeal persons. The statutes of most states make it a felony for one or more persons to conspire to move or maintain a fraudulent suit, action, or proceeding in the name of we the people. Do you think that there's a few of those that happen every day of the week in every state of the Union and every county? And if fraud is evident, the statute of limitations is waived. All will agree that artificial persons are not void of capacity to do wrong. All will agree that an artificial person acting beyond the scope of its powers is acting ultra vires of its authority. Okay, let's look at the definition of ultra vires in case that's confusing to some. The modern technical designation in the law of corporations of acts beyond the scope of their power as defined by their charters or acts of incorporation. It was early contended that a corporation could not exceed its powers, that the acts of its agents beyond the charter powers of the corporation were not the acts of the corporation. But it is now well settled that corporations, like natural persons, have power and capacity to do wrong. They may, in their dealings and contracts, break over the liability imposed upon them by their charters, and when they do so, their exemption from liability cannot be claimed on the mere ground that they have no attributes or facilities which render it possible for them thus to act. By default, no act of the incorporeal person by and through its agents may be deemed to be the acts of the sovereign, unless such acts are lawful, because all acts of the king must be lawful by operation of law. Because of the constitutions, it is legally impossible for the sovereign people to violate Magna Carta and fall prey to Magna Carta Article 61, because all acts of the sovereign are lawful. As Thomas Jefferson said so well, in questions of power, then, let no more be heard of confidence in man, but bind him down for mischief by the chains of the Constitution. That puts the ball squarely in the court of the incorporeal person, not the sovereign. The genius of the system is that it totally immunizes the sovereign, the we the people, from any unlawful act by its sworn public servants and legal licensees, on or off the bench, state or federal. So under no circumstances can the sovereign be presumed to have waived immunity. And such servants have official immunity only when their acts are lawful, because the sovereign has immunity only when his acts are lawful. By the means of delegation, then, all acts of the sovereign people are lawful. Only the sovereign people, then, have true sovereign immunity. While holding public office under oath, even we the people waive sovereign immunity during our term of office, being bound by the rights, duties, capacities, incapacities, privileges, and immunities signed to that office by operation of law. President James Polk said in his retirement speech, "I will soon cease to be a servant and become a sovereign." Having delegated the duties of the king to persons under the incorporeal persons, about the only duty left to we the people is to hold our servants strictly accountable to the rights, duties, capacities, incapacities, privileges, and immunities assigned to their various offices by operation of law. Now, the framers of the 1849 California Constitution stated the premise most eloquently in their open letter to we the people. A free people in the enjoyment of elective government capable of securing their civil, religious, and political rights may rest assured these inestimable privileges can never be wrested from them so long as they keep a watchful eye on the operations of their government and hold to strict accountability those to whom power is delegated. Continuing, no people were ever yet enslaved who knew and dared maintain the correlative rights and obligations of free and independent citizens. A knowledge of the laws, their moral force and efficacy, thus becomes an essential element of freedom and makes public education of primary importance. Well, we fell down there. Our public education doesn't teach us squat about who holds the sovereignty in this country, who the people are, who the persons are, and what type of government we're supposed to have. It's failed us miserably, and it's done so on purpose because the government has taken over that education system, and this is what we have now. Even in law school, nothing that you're learning here today is ever taught in law school. They have a completely different picture. All they're taught in law school is personal law, not the law of the sovereign. The governments of the several states have no legal capacity to determine who its sovereign is. That matter was well settled in international law in 1783 with the signing of the definitive Treaty of Peace, binding on every judge in each of the several states and of the United States of America under the Constitution, Article 6, Section 2, and the phrase, all treaties already made. So would you say that the Treaty of Peace is a treaty already made? So I just want to thank you for listening to that. We're going to have to understand how that the people immunize themselves, and that we've put all this liability on the government and the government employees, and when they get outside of what they do, that's ultra-virus, and they are personally liable The judge himself is personally liable. The attorney is personally liable. The sheriff is personally liable. These persons need to understand the law, and we're going to have to teach it to them somehow. Okay, that completes that section. Okay, how do the people hold their sworn public servants to their allegiance to the people? We're going to look at a case from California, Steiner versus Darby, as an example of how this works, and as one way that it works. And there were two questions up for grabs in this case. One was, which were, may the Board of Supervisors of the County of Los Angeles require the officers and employees under its jurisdiction to, number one, take an oath of allegiance to the federal and state constitutions and the laws of California as against all enemies of the United States of America and the state. And the second question was, could they require such officers and employees to answer upon their oaths certain questions that touch upon the oath of allegiance? In order to understand all of this, I'm going to read to you a couple pages of selected excerpts from this case so that you have the context of the case and you can understand the background for the point that we're trying to make here. So here we go. Steiner versus Darby. The people of the state of California are supreme and have the undoubted right to protect themselves and to preserve the form of government which they have adopted against any and all enemies, whether they be domestic or foreign. It is not alone the right of the people to protect themselves and their chosen form of government against attack from all sources, but it is their duty to do so, since they have guaranteed to the people of the United States of America a republican form of government in all states, as we've cited from Article 4, Section 4 of the U.S. Constitution. And it's also in Article 1, Section 3 of the Constitution of California. Continuing, every citizen is a minority member of society in the form of government which the people of the several states have adopted guarantees to each minority member, as well as to the majority, a republican form of government in his own state. Such form of government has long since passed through the experimental stage. It has proved to be the most satisfying to the aspirations of mankind, and at the same time the most practical government yet devised. Trial and experience have demonstrated it to be the best form of government that this world has ever known. Our system has maintained democratic processes, improved the condition of the people, preserved liberty, promoted justice, encouraged the arts and sciences, and served the needs of changing peoples. The people, acting through their duly authorized representatives, have assumed the foregoing obligation and have plenary, meaning complete in every aspect, absolute, unqualified power to perform it under any and all conditions. The supreme limit to which the people may exercise this power is found in their undisputed right to require a citizen to give his time, be maimed, or even sacrifice his own life in defense of his country. In United States versus McIntosh, Mr. Justice Sutherland, in discussing the question of an individual citizen's allegiance to the government of the United States, succinctly states the situation as follows. In Jacobson versus Massachusetts, this court, speaking of the liberties guaranteed to the individual by the 14th Amendment, said, and yet he may be, the citizen may be compelled by force if need be, against his will and without regard to his personal wishes or his pecuniary interest or even his religious or political convictions, to take his place in the ranks of the army of his country and risk the chance of being shot down in its defense. We are a nation with the duty to survive, a nation whose constitution contemplates war as well as peace, whose government must go forward upon the assumption and safely can proceed upon no other, that unqualified allegiance to the Union and submission and obedience to the laws of the land, as well those made for war as made for peace, are not inconsistent with the will of God. Clearly, since the government of the United States has the right to force an individual citizen, a minority member of society, to surrender his life in defense of his country, any state, in attempting to perpetuate its loyalty to the Union, has the unquestioned right and duty to exact from its citizens adherence to all lesser measures which have for their purposes the preservation of our form of government and the repression of its enemies, foreign and domestic. Therefore, when a person enters the employ of this state or any subdivision thereof, he impliedly surrenders certain natural rights, which would remain his if he were a private citizen only, just the same as he would surrender certain privileges if he were to enter private employment. There are few employments for hire in which the servant does not agree to suspend his constitutional rights of free speech, as well as of idleness by the implied terms of his contract. Quoting from Crystal versus Police Commission, there is nothing startling in the concept of a public servant's rights to retain his office or employment should depend upon his willingness to forego his constitutional rights and privileges to the extent that the exercise of such rights and privileges may be inconsistent with the performance of the duties of his office or employment. Back to the case. The foregoing cases support the obvious rule that plaintiffs, as public servants, have the implied duty to support the form of government, a republic, lawfully chosen by the people whom they are employed to represent, and that they impliedly agreed, when they accepted public employment, to act as representatives of the people and not to advocate destruction of the government by force or violence. By accepting public employment, they forego any privilege they may have had as private citizens to advocate the overthrow of the government by force or violence. It is inconceivable that they should be permitted to represent the people, be supported by the people, and at the same time have the privilege of advocating the overthrow of the very government for which they are employed and obtain their livelihood. It needs no argument to support the thesis that their employer, the people of the state of California, need not wait until after an employee has committed some overt act before making inquiry as to his fitness to occupy the position which he holds. A servant employed by the people is held to an even higher standard than as to a private employer, and his employer, the people, not only may, but it is their duty through their authorized representatives to make proper inquiry as to his fitness for the position which he occupies and as to his intentions and acts relative to his loyalty to the people. If a private organization, such as the Protective Order of Elks, can lawfully require a loyalty obligation, without question the people may require such an obligation from a person seeking to remain in a public position with its attendant prerequisites and manifold benefits. The obligation or oath required of defendants, here these are employees who didn't want to take an oath, is substantially the same as that which a foreign-born person is required to take before becoming entitled to the honor, benefits, and privileges of being a naturalized citizen of the United States. Since a naturalized citizen has the same rights and duties as a native-born, with certain constitutional exceptions, there is not any logical reason why a native-born citizen should object to assuming a similar obligation. So if someone moves to this country to become naturalized and has to take the oath, why isn't it that one of the citizens here is here already and is wanting to work for the government? Why shouldn't they have to take the same oath, is what they're saying. It seems self-evident then that aside from any restraining constitutional provision, the Board of Supervisors itself, or through its agents, duly authorized, may investigate to its heart's content the character, the antecedents, the viewpoints, and the affiliations of any of its employees, including those in the civil service, so long as the investigation does not touch upon the political or religious opinions or affiliations of the employee. Moreover, it would seem to follow that so long as the Board does not impinge upon these restrictions, it may, like any private employer, demand of its employee an oath, if it chooses, and a response to a questionnaire as a basis in whole or in part for his discharge. The county may question its employees and demand unquestionable loyalty in the manner it lays down, except as restricted by law. So, puts things pretty much in perspective for me. Very few in government, whether they know it or not, are upholding the Constitution and their oath, and almost all of them, in some degree or another, whether they know it or not, whether it's meaningful or by meaning or not, on purpose or not, are actually acting as enemies of the government, enemies of a Republican form of government, and are not supporting it. They're actually doing their best to destroy it, whether they know it or not. And I don't care whether they know it or not. I would like for them to know what they're doing, but regardless, they are responsible for their actions. So let's see if we can create a remedy out of this. The public servant has no immunity, as we've seen, against being required to take an oath of allegiance against all enemies, both foreign and domestic, of the United States of America and of the state. The public servant has no immunity against being required to answer upon their oath questions that touch upon that oath of allegiance. We know that the right of a Republican form of government is guaranteed in Article 3, Section 4 of the Constitution, is in fact a property right, and a pretty darn precious one at that, of which no state shall deprive any person pursuant to Section 1 of the 14th Amendment to the Constitution. The people have a duty to enforce on every sworn public official their duty to support such a Republican form of government and not to advocate the destruction of same. So in any instance where any sworn public official is not supporting a Republican form of government in the state, any person or any one of the people may access a 25 people, Article 61, Magna Carta grand jury to have the error of the transgression against any person or any one of the people amended without delay. And there is nothing in Article 61 of Magna Carta that prevents a multiple party action being brought before the four barons, the people, for a petition to the government for redress of grievances. So it would seem then that every living, breathing person or sovereign people in this country has an immediate biggie-sized grievance to bring to the attention of four of those barons, to four of the people. And that's a course of action that should be taken across this country en masse immediately. Okay, we're moving on to the last section before we conclude everything. And this section is about remedies. We have to understand that anything the government does to limit, restrict, abolish, or hinder in any manner the rights of the people is done in derogation of sovereignty is actionable by the people. This extends to any actions by government that are ultra-vires to the powers specifically granted to the government by the people. And since there are so many wonderful creative ways in which the government can catch the dreaded ultra-virus, let's list some of the remedies that we have available. Because the reason we're going to list these is several reasons. One, we want to have them all in mind. And two is sometimes we feel like there's nothing we can do. And I understand that it's difficult enforcing any remedy these days. But regardless, we have so many remedies and we need to keep them in mind and review them every once in a while so that we are aware of all the remedies that we have and we can keep looking for ways to enforce them. Okay, it is the right of the people to alter or to abolish the Constitution and government they have created and to institute new government. It's contained in the Declaration of Independence, our first Constitution. Amendment 1, the right of freedom of speech and of press. Number 2, the right to peaceably assemble. Amendment 1. Okay, then we have again Amendment 1, the right to petition the government for redress of grievances. We've learned that we have, out of Article 61 of Magna Carta, the 25 people Magna Carta grand jury has the right to petition government for grievances, understanding that the ruling of this grand jury may not be overturned by any court in the land, and that the decisions of this grand jury can overturn the ruling of any court in the land and overturn any law passed by any legislature in the land. The persons may request the four members of the grand jury to petition the government on their behalf. Okay, and the people have the right to keep and bear arms. Amendment 2. Any one of the people may join with a person that's already a plaintiff, may join as a co-plaintiff in an action brought against the government in the manner of a mandamus to enforce the rights of the persons. Any one of the people can require the Attorney General to represent him in court, even if the people has joined with a person already a plaintiff, as a co-plaintiff in an action brought against the government in the manner of a mandamus to enforce the rights of the person. The people can exercise those political rights, that legislative authority reserved to the people, which political rights originated from the Declaration of Independence and were reserved to the people by default upon the adoption of the 1787 Constitution. Among these political rights is the right to vote and to run for political office. Have a right to trial by a jury of your peers, understanding that if you are a people, a jury of your peers is an all-people jury. Okay, well, now we've covered a lot of ground in this course, so let's summarize some of the major points and bring them all together, put them in perspective, and provide a list that you can easily access and think about remedies and rights as you go about your business. First, we know that government owes duties to the sovereign people, and we'll list some of those duties that are owed. The government may not deprive or hinder any person who shall be the next in succession to the crown. That's the Treason Act of 1703. And we know that the Attorney General's duties are to the sovereign rather than to the machinery of government. People can request the Attorney General to represent him in court, and the government has to provide their own attorney at their own cost. The United States shall guarantee to every state in this union a republican form of government. It's an obligation on the government, a duty owed by the government. The United States shall protect each of the states against invasion and against domestic violence. Article 4, Section 4. Public servants have the implied duty to support the form of government, a republic, lawfully chosen by the people, whom they are employed to represent, and that they impliedly agreed, when they accepted public employment, to act as representatives of the people and not to advocate destruction of the government by force or violence. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. Article 6, Section 2. So laws and treaties not made in pursuance of the Constitution are not the supreme law of the land. They are unconstitutional. They do not exist. And as we said, the Treaty of Peace was the first treaty, and it's absolutely enforceable. Judges in every state shall be bound thereby to the Constitution, the laws of the United States made in pursuance thereof, and all treaties. Anything in the constitutional laws of any state to the contrary notwithstanding. Again, judges are bound to the treaties. They are bound to the Treaty of Peace, 1787. They cannot get around that. The people's sovereignty is secure there, and the judges have to abide by it. Likewise, the senators and representatives and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. They're all tied up. They're all tied up by this. Let's look at a list of limitations and restrictions on the government placed by the sovereign people. Again, all these lists are incomplete. They're not all encompassing, but they're the major issues. There's plenty more other things we can talk about. Neither the courts nor any sworn public official has any measure of public sovereign immunity. They are fully liable for all their actions, and when their actions exceed their authority granted, those actions are ultra vires. All individuals so involved are liable in their personal capacity. The U.S. Supreme Court in Chisholm v. Georgia stated that any acts by a state in the manner of those included in the list of powers prohibited to the state in Article 1, Section 10 of the Constitution, which is a very long list, may, injure individuals in their property, their liberty, and their lives, may oppress sister states, and may act in derogation of the general sovereignty. Article 1, Section 9 of the Constitution specifically places limitations on powers granted to the United States of America. Thus, any acts by the United States in the manner of those which are included in the list would be in derogation of the sovereignty pursuant to the rule in Chisholm versus Georgia. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Powers denied are not to be implied, they are to be obtained, if at all, from and in the same manner provided by those who originally granted the enumerated powers, but who at the same time denied other powers. The government is only sovereign as to those it creates. Okay? It did not create the people created it. The people are sovereign as to the government. No fiction can make a natural born to be subject. The government can't make the people to be subject to it. All legislative authority is not vested in the General Assembly or Congress, for they are confined to the civil department, while the political is reserved to the people. Okay, we're at our conclusions now. And again, I'll repeat this. If you are one of the people, when you sign documents, here is how you identify yourself. You sign your name at the end of the document, and you type under there the 2009 posterity of the 1787 We the People of the Preamble to the Constitution for the United States of America, a joint tenant in the sovereignty of both the United States of America and of the state of, put in the name of your state. That is how you should sign your name. That identifies correctly who you are. In addition to that, in the introductory paragraphs to a pleading, judicial notices, letters, etc., wherever it comes in handy, you should introduce yourself as follows. From the undersigned in his or her proper legal capacity as a member of that class known as the 2009 posterity of the 1787 We the People and the Preamble to the Constitution for the United States of America. And the next part in parentheses here is, I've given an example in California. You would insert the words under Government Code Section 100. In other states, you'll have to find what the corresponding code might be. Within the meaning of the word sovereign in the Treaty of Peace of 1783, who is not a U.S. citizen, U.S. Constitution, Article 191, U.S. 14 Stat 37, 14th Amendment, federal citizen of the United States. The undersigned is a member of that class known in the preamble to the state, here in state name, Constitution, as people as opposed to person. Now, you continue that with the following statement, explaining what it means. That statement means that I am one of the rare individuals in this state who hold both the sovereignty of the United States of America and the sovereignty of your state name, who can enforce the United States Constitution in the courts of the United States and of the state through Article 6, paragraphs 2 and 3. And, just importantly, who understand the significance of my legal status. You need to understand this stuff. That's why we're presenting this course. And its attendant rights, duties, capacities, incapacities, privileges, and immunities, and how they relate to every other legally recognized class of persons, both real and incorporeal, understanding that a capacity vested in one legally recognized class creates a total incapacity in all other legally recognized classes. As such, personal statutes such as the Civil Code of Procedure, Penal Code, custom table of that list for your state, and the names might change, all of which were enacted to comply with the Civil Rights Enforcement Act of 1870, it's U.S. 16 Stat 114, to comply with the Equal Protection Clause of Amendment 14, which only applies to the person in Section 1 of Amendment 14, and do not apply to your name when they are in derogation of sovereignty. Nothing may be done in derogation of sovereignty. So, the people have certain powers and rights without which this country does not exist. Some of the changes needed in this country can be effected only by the people. Most will require the cooperative efforts of the people and the persons. Together, we must all work to create the changes that America so desperately needs. The people created the Constitution and established this country for themselves and their posterity. After all, they were pretty much the only ones here at that time. However, the people also have an absolute duty to protect the rights of the persons. So what are we to do now? Study this course until you own it. Find out who you are. If you're one of the people, document your lineage. Then go study some more. Spread the word about this information to everyone you meet. Spread our website around. Let everybody know to go there so they can find out this information. Everyone needs to be informed about this, not just a few. The future of this country absolutely depends on your knowledge and your taking action. Everybody, you already have everything you need to fix the republic. Everybody go out and take it back while there's still something to salvage. This is not the end of our course, but rather just the beginning. Watch our website for announcement of further education about legal status in the USA. Together we can do it. We have to work together. I want you to be aware of some of the things we're considering for educational seminars in the future. Things we're thinking about addressing are how to deal with mortgages and prevent foreclosures, how to prepare a request to take judicial notice of your legal status and other issues, why a summary proceeding cannot be brought against the people, why no writ of possession can be brought against the people, and why no order to show cause can be brought against the people. So there's more remedies coming. We're going to look at things such as why there is no statute of limitations applicable to the actions of the people. We'll look at Fourth Amendment warrants in the people, how to operate in court as a sovereign, and putting the remedies we have discussed into practice. Additionally, we're going to look at why the sovereign people cannot be dispossessed of these rights that follow. After all, he or she is entitled to the enjoyment of them in such a way as to achieve happiness. What a nice standard to have. Has the right to life, liberty, right to real or personal property, right to property that is in his possession, even if he does not personally own the property, and right to not be sued. Again, he has the right to those in such a manner as to achieve happiness. And the definition of happiness can only lie with the people, not with some court. In conclusion, we're going to recite, repeat some quotations that I think you'll find of interest. U.S. Supreme Court Justice James Wilson, the signer of the Declaration of Independence, gave the first regular course of law lectures in America at the University of Pennsylvania in 1790, where he said, "The science of law should, in some measure and in some degree, be the study of every free citizen and of every free man," noting that the law to which he refers is in fact the common law of England, which is the subject of this instant treatise. Notice that free citizen and free man, used above, are two different things, and they are distinctly two different classes of legally recognized individuals, each with different rights and duties assigned by operation of law. In other words, a person who is immigrating under the authority of Article 1, Section 9, Clause 1 of the Constitution may in fact be a free man, but until he has been naturalized, he is not a free citizen. Mr. Justice James Wilson concludes, "Every free citizen and every free man has duties to perform and rights to claim, and unless and until in some measure and in some degree he knows these duties and those rights, which is the study of the subject of legal status of persons, he can never act a just and independent part." Several quotes from Andrew Jackson. "The people are the government, administering it by their agents. They are the government, the sovereign power. I feel in the depths of my soul that it is the highest, most sacred, and most irreversible part of my obligation to preserve the union of these states, although it may cost me my life, which it did. The brave man inattentive to his duties is worth little more to this country than the coward who deserts in the hour of danger. One man with courage makes a majority. Well, that concludes our course on legal status. I want to thank every one of you very much for participating in this course. Again, I want to invite you to visit us on our weekly question and answer calls for a lively discussion of these issues, and where we can answer your questions about anything here that you do not understand. Again, I can't overemphasize how important it is that we need everyone in this country to be exposed to this information. It is the fundamental information that's absolutely required to turn this country around and bring the republic back. Cannot be done without it, absolutely, positively. So we need to get everyone involved in this process, in this learning process. We are putting short videos up on YouTube and other places to help bring it to the attention of Americans. We ask that you encourage everyone you know, everyone you meet and run into to participate, to go see the videos, to go to our website, and to go forward and take this course. With this knowledge in hand, I think we can make a big difference. In fact, I know we can make a big difference. People have to get back in control. People and the persons need to know who they are, what their rights, duties, capacities, incapacities, privileges, and immunities are for their particular legal status, and how they can work together to take control back of what we have going on in this government that's completely running away with power and acting as if they are the sovereign, that they have sovereign immunity. As we've stated before, nothing could be further from the truth. We are the solution we're looking for, and we have to do the things, put into effect the remedies that we've talked about here, research them further, implement them, determine the processes, and we'll be looking for your help with that. We will continue our research, continue to provide additional education, and we look forward to meeting all of you and working with you in the future. Thank you very much. God bless America. Goodbye.